brief. They'll just be here in exactly 2 minutes. And we'll request you to keep your mobiles on silent mode, please.
Bench, am I clearly audible?
Yes.
May it please this Honorable Court, I am the counsel of Team 2511, appearing on behalf of the appellants in the case of Mr. Yara Mixol versus the State of Moda. Lords, the present appeal has been filed by Mr. Yara seeking setting aside of his conviction for the offences of culpable homicide and being a part of an unlawful assembly armed with a deadly weapon. The State has also filed a counter appeal seeking a conviction under the offence of murder, Lords. To take my lordship background, the factual matrix of the case, Lords, the country of Ionia, it had introduced model aimed to digitize the criminal justice system. Lords, on the fateful day of the event, during the Prime Minister's election campaign rally, a paintball pellet was shot towards the stage, while the first pellet missed hitting the Prime Minister of the BNS and Section 189 subsection 4. So appellant has come before this honorable court challenging his conviction, the admissibility and reliability of the Crime 360 report, and lastly the fairness of the trial. So Lords, moving on to my submissions, the first issue pertains to the inadmissibility of the Crime 360 report, and for this I will be making primarily a threefold argument. Firstly, Lords, I would be submitting how the present law of evidence, it is not equipped to admit artificial intelligence generated evidence, Lords. Secondly, Lords, the materials that were collected to create that report, they were collected in violation of the appellant's fundamental rights. And lastly, my Lords, there are significant, and Lords, moving on to my first submission as to how the present law of evidence, it is not equipped to admit AI generated evidence. I would be drawing a very simple difference between the traditional forms of electronic evidence which are admissible before my Lords after a section 63 certificate is attached, such as WhatsApp chats, emails. But Lords, AI generated evidence, it differs from this because it is not a mere digital copy of something. Lords, it is an opinion of the AI model based on all the data sets that it is fed and all the designs and algorithms it functions on. So the question I pose before my Lords is whether the same safeguards that we have for these types of evidence such as emails, WhatsApps, mere digital copies, can those be extended to machine generated data as well, Lords? And considering the fact that this is the first case where an AI model is being used in a criminal trial, there are still significant inherent risks that are yet to be explored. So therefore, Lords, it cannot be admissible before my Lords. Secondly, Lords, the report was also created using materials that violate the appellant's fundamental rights, particularly the right against privacy and the right against self-incrimination. Lords, the Council is aware that the right to privacy is not an absolute right. There are reasonable restrictions, such as, but those restrictions, they have to meet the threefold test which was laid down in the case of K.S. Puttaswamy. Lords, the threefold test, it requires that firstly there must be a valid law that allows that particular act, Lords. But in the present case, the Crime 360 model, there is no law that exists in the country of Ionia which allows the functioning of the Crime 360 model or which regulates its operations. There is only an Ionian Criminal Identification Act which is merely limited to the collection of measurements. It nowhere mentions that we are allowing an AI model to operate and get this data and process it and come to results. Secondly, Lords, the first condition does not exist, Lords. There is no law. The second condition postulates that there must be a legitimate state aim. Lords, in the present case, under the guise of public interest and under the guise of enhancing the criminal justice system, Lords, this model was actually brought in just to over-police the minority community, Lords. So this is just a facade that is being put up that there is a legitimate state interest and we just want to make an integrated criminal justice system. It is just something that facilitates mass surveillance and it targets the minority, Lords. And lastly, the principle of proportionality is also not met due to the nature of data that it is obtaining from the appellant, Lords. Because if my Lords may refer to document B of the Moot proposition, due to the sake of brevity, I will tell my Lords what it is about. It mentions that the geolocation of the appellant was also tracked by the AI model. But Lords, this feature is nowhere revealed in their brochure that we will also be accessing your geolocation. So Lords, therefore this further goes on to show a blatant disregard for any sort of individual privacy, Lords. Lords, as regarding the right against self-incrimination, the appellant's face print was collected. Lords, it was initially collected for the purposes of identification, just to see that whether the person who was shown in the footage, whether he was the one who shot the gun. But later, that very face print, it was also used to gain access to his devices, that too without his consent. So, Lords, the Council is aware that in the case of State of Bombay versus Kathi Kalu, the court observed that under the spirit of Article 20, Clause 3, to be a witness merely means to provide evidence against oneself in terms of oral or written testimony, that's it. And now my Lords may pose a question in front of me that if a face print, it is neither an oral testimony nor a written testimony, then how can it amount to being a witness? To this I submit, Lords, that when Kathi Kalu was decided, technology was way less advanced. At that point, the court could not have foreseen that in some time in near future, it would be possible to obtain information from a person's personal knowledge without going into the scope of oral or written testimony. My lords, today, a password, when we ask someone to disclose their passwords, that is again self-incrimination, lords, as has been held by, observed by the Delhi High Court in a recent case, that is Sanket Bhadresh Modi versus CBI.
Now tell me, I want to ask a question here.
Yes.
See, when Crime 360 report
Yes.
itself, where you're saying that it is in violation of the right against self-incrimination, when the AI technology was only uses the data which is publicly available. So therefore, and it is not based upon any statement made by any individual, then how can you even say that this Crime 360 report is in violation of the right against self-incrimination?
Indeed, my lady, it was accessing data that was publicly available, but my geolocation was not publicly available, my lady. The Crime 360 model, it had automatic access to my location without even informing me, without my consent. So it was not only public data that it was accessing, if that answers my lady's question.
How do you get the geolocation?
Lords, that they have not revealed how the Crime 360 report, it just mentions that when the chaos ensued at the event, the Crime 360 application, it could automatically place Mr. Yara at the scene due to his geolocation.
Are you assuming that there is some kind of a tag which is there in somebody and that is how we are able to geolocate somebody electronically?
Lords, the geolocation, it is accessible through one's phone as well, Lords.
Right?
Yes, but the brochure of the Crime 360 model, it nowhere mentions that we will be accessing the geolocation as well. It mentions about the other things.
I think it is implied there in the fact that there is some kind of a device which is transmitting your geolocation to people at large, by and large, which I would assume, as you rightly said, perhaps a mobile phone.
Yes, Lords.
Perhaps.
Lords, all I am saying is that we have been provided with a detailed brochure of the Crime 360 model.
Fair
it
enough.
lays down the details of what
Fair
we are
enough.
accessing. And it doesn't mention geolocation,
Fair
Lords.
No, but irrespective of the geolocation,
Yes.
what you're saying, there are two witnesses who have categorically stated that you were present at the scene and they've recognized you. And not only that, even the camera outside your residence clearly showed that you were wearing the same clothes at the time of exiting your residence, and when you came back and it recognized, and so your presence at the crime scene is established. It's in spite of the fact whether or not this AI was used or not.
Indeed, my lady, through the point of geolocation, I am only talking about privacy. I would like to clarify that I am not disputing my presence at the event, because the crime scene, the event that is being referred to, it is an election campaign rally, lady, my lady, which was also a concert where Dolji Dosanjh was performing, and there were a gathering of more than 50,000 people. So it must be that Yara Mixol had merely gone to attend that rally or to listen to the singer merely, and the two eyewitnesses that saw him, Lords, they did not see any weapon in his hands. A paintball pellet gun is a big weapon. In a gathering of 50,000 people, no one saw him entering with a gun or leaving with a gun. They only confirmed that he was standing there. That's it.
No, but once you're not disputing your presence,
Yes.
then this issue with respect to geolocation technology being used, it really doesn't help you at all.
My lady, I would beg to differ on this point. I merely submit that my geolocation was being tracked against my consent. So that is a violation of my privacy. The geolocation has already placed me on the scene of crime, that I am not disputing. Because it was a gathering of 50,000 people. It was an election rally, a concert also. So I was just there to attend that.
All right, you may proceed.
Yes. Lords, even after this, if my lords differ from me and they do admit the Crime 360 report, I would just like to point out the risks in relying on such a piece of evidence. My lords, AI models, they function on complex algorithms in the sense that there is no way to understand how it comes to a certain conclusion, what exact data sets it is trained on, and this is also called as the black box problem, lords. It is very well recognized internationally. And my lords, unlike a human expert, we cannot put an AI model on stands and question it about how it came to those results. And lastly, my lords, there is also an element of bias which has been recognized, because AI models, they operate on human inputs. And if the data that is fed to that AI model, if it itself contains biases, then that AI model would just go on to reinforce and replicate those biases. So lords, this is a very nascent stage. We cannot allow to such a piece of evidence to operate in a criminal trial and lead to the conviction of the appellant, lords. Lords, now I would be moving on to issue 2, which pertains to conviction of the appellant for the offence of culpable homicide. Lords, while I will be taking my lords through the ingredients of the offence, which is the core of my argument, as a preliminary submission, I would just like to clarify that there have been lapses in identification of the accused itself. Because, my lords, the crime 360 report, which was the initial evidence, that is the only evidence that has identified the accused at the scene of the crime holding the gun. It shows only a 92% likelihood that he was the one who was holding the gun. And my ladyship pointed out that there was a CCTV footage. But in that CCTV footage, Mr. Yara was wearing a mask. The CCTV footage shows that the person who shot the pellet gun, he was wearing a mask, not Mr. Yara. So, my lords, I apologize. So, any claims that the AI model makes that I have accurately identified the accused, they fail because his face was covered, lords. And furthermore, the report also mentions that it is not sure about whether the person who had the gun, he only shot it or it was the person next to him. That the report mentions in its results. And apart from that also, the report has also pointed out 2 other individuals, that is John Doe and Ricky Mixall, with significantly high probabilities, 80% and 82%. Yet no further investigation was conducted to find out whether they were holding the gun or not. It was only Mr. Yara who was targeted, lords. Now coming on to the essentials of the offence of culpable homicide, the first essential that we have to establish is that there must be a direct cause between the injury and the subsequent death. But lords, the first fact is that we have not established who caused the death. So the very fact, if we are not sure about who actually caused the death, there is not a direct link between the act and the subsequent death. And regarding the presence of either intention or knowledge, lords, it could not, even if my lords agree that it was Mr. Yara, let us suppose that he shot the paintball pellet, even then, my lords, it cannot be reasonably foreseen, even from the point of view of an ordinary prudent man, that the consequence of mere shooting a paintball pellet, which is also used as a recreational tool in games, that would lead to an injury that would ultimately lead to death. In the worst case scenario also, such an injury might in the worst case scenario, it may lead to a loss of eyesight, lords, but not death. So therefore, no knowledge can be attributed to the appellant. Mere dissatisfaction with the ruling government may...
What was the intent of carrying the gun then?
Lords, he was not carrying the gun. There was no proof that he was the one who was carrying the gun.
No, but then the gun was discovered on the basis of your testimony.
Lords, I would be disputing the confession and the recovery of the gun, because, my lords, there are significant inconsistencies in that, in the recovery also. Because firstly, my lords, the recovery was made from a public place. Technically, it should be made from the weapon should be recovered from a concealed location where the police could not have reached otherwise than the assistance of the accused. But this was recovered only half a kilometer away, that too from behind a public dustbin. It was not hidden or buried anywhere. Secondly, no independent witnesses were joined to effect the recovery. The investigating officer, he also failed to include a detailed description of the weapon. And moreover, my lords, the fact that is admissible under the old section 27 and the new section 23, it pertains to the knowledge of the accused, not the object that was recovered. And in the present case, lords, if lords would see the confession or the pointing out memo, the accused has nowhere revealed that I would take you to this particular road and get the weapon recovered from there. The details of the location are nowhere mentioned, lords. So there are significant inconsistencies which creates doubt about the alleged recovery and the confession, lords. If my lady is satisfied?
Proceed.
Lords, I have established how the ingredients of the offence have not been met, and I have disputed the recovery and the confession. Now I would be moving on to my last submission under this issue, under which I submit that the right to fair trial of the appellant was also infringed, because, my lords, he was not supplied with the documents he needed, that is the data sets and the source codes of the crime 360 model on which it was created. And due to this, lords, he could not effectively cross-examine the prosecution witnesses. He could not put his defense, he could not put forth his defense effectively, thereby violating his right to fair trial. So, my lords, I would just conclude by saying that what we have come to is that I have to prove that I am innocent because a computer is saying that I am guilty. And the case of the prosecution, it is full of improprieties. So the only question is that how many are my lords willing to ignore? That is all I submit, my lords. It was a pleasure arguing before the bench. Thank you for the court's gracious time. If my lords have any other queries for me.
Thank you.
Much obliged, so grateful.
Okay. So we start with the next one.
Greetings to the Honorable Bench. Am I audible?
Yes.
May it please this Honorable Court, I am the co-counsel for the appellant and I will be dealing with issues 3 and 4 today. My lords, the issue 3 deals with whether the conviction of the appellant, whether the appellant is liable for conviction under section 103 subsection 1 of the BNS. My lords, under this issue we respectfully submit that the appellant is not liable for a conviction under section 103 subsection of the subsection 1 of the BNS. My lords, at the very foundation of our argument lies the fundamental distinction that lies between culpable homicide and murder, a distinction that is very well recognized within the BNS. My lords, section 101 of the BNS lists out certain special conditions under clause A to D of section 101, and only when these special conditions are met, then an act comes under the offense of murder, my lords. My lords, in the present case, it is on the prosecution to first establish that the appellant knew that his action was so dangerous that in all certainty and probability it would cause death or serious injury. However, my lords, there is no proof of such knowledge in the present case. My lords, in the present case, the appellant has allegedly fired a paintball gun at a crowded event which caused a stampede, and that stampede further led to the death that happened. But my lords, there is no direct link between the act of the appellant and the death caused.
The very fact that you were carrying a gun and the fact that a bullet was fired and in a gathering which had approximately 50 to 60,000 people. So wouldn't you know that if such an action was done on your part, even if there was some injury and it would lead to a situation of stampede and chaos, that situation may worsen and it may lead to certain consequences which could be fatal. So you were totally aware that you were not in a setting where it was just a few people, but it was a large gathering. So you should be aware of the consequences of your action then.
My lady, under clause D of section 101, the requisite for knowledge that is needed is to the highest degree of probability. And my lady, in the present case, we cannot say that the appellant's alleged act, from the alleged act, we can derive that the appellant had this requisite knowledge. I say this because, my lady, because the need is for the highest degree of probability, it cannot be said that the appellant had the knowledge that if he will fire a paintball gun in such a big gathering, a stampede will occur, and then because of the stampede, a particular targeted death will occur. At max, what he could have known is that certain chaos could have occurred, and that too, it depends, my lords, on crowd to crowd. And in addition to that, my lords, the appellant was carrying a paintball gun. And my lords, paintball gun by its very nature is not a lethal weapon. It is a recreational toy. It is used in games, in arcades and for tournaments, and it is not, by its inherent design itself, it is not capable of causing any grave injury or fatal consequences. Thus, my lords, both these things show us that the appellant did not have any requisite intention or knowledge that his alleged act will lead to a stampede and that will further cause the death, my lords. Thus, my lords, because the essentials are not being met under section 103 subsection 1, my lords, the appellant is not liable for a conviction under the requisite section, my lords. My lords, coming to the fourth issue at hand, the fourth issue deals with whether the conviction of the appellant under section 189 subsection 4 of the BNS is bad in law. In this regards, my lords, I will be making two submissions. That firstly, the essential of 5 or more persons has not been established in the present case, and secondly, that there was no shared common object. Coming to my first submission, my lords, I would like to submit that for a conviction under section 189 subsection 4, what firstly needs to be established is that there needs to be an unlawful assembly, and for that we need to establish that there was a presence of 5 or more persons and that there was a shared common object amongst these persons that were constituting the unlawful assembly. However, my lords, both these essentials have not been met in the present case, and for this, my lords, firstly, to satisfy how the first essential is not met, I would like to draw your attention to paragraph 9 of the Moot proposition, my lords, on page 3, if you may direct your attention.
Which is the Moot problem?
Of the Moot proposition, my lords. Paragraph 9, page 3.
Is this the one you're referring to?
Yes, my lords.
This one.
My lords, this, are you with me, my lords?
Page 3, did you refer?
Yes, my lords.
Yeah.
Paragraph 9.
Please continue.
My lords, the paragraph talks about the offence report. My lords, the paragraph talks about the offence report, which initially named 5 individuals as the accused. These were Gauri Lydia, Ricky Mixol, Fuzail Iqbal, Fanny Luang and Krish Kumar, and along with other unidentified persons. My lords, what I would like to highlight over here is that Yara Mixol, that is the appellant, is not amongst these identified individuals. Secondly, my lords, now I would like to direct your attention to document B, my lords, on page 9. Or I think there's some discrepancy within the numbering. It is on page 10, my lords.
Yes.
Yes, my lords. My lords, the crime 360 this is the crime 360 forensic analysis report, and within the table, my lord, it presents an entirely different set of 5 suspects, which were John Doe, Yara Mixol, Thang Luang, Krish Kumar, and Ricky Mixol. My lords, when we compare these 2 reports, we can only find 2 common individuals between them, that is Ricky Mixol and Krish Kumar, my lords. My lords, this raises a serious doubt about the inconsistency within the reports, my lords, as the reports which the prosecution has heavily relied upon, they have not been able to pinpoint exactly which members were constituting an unlawful assembly in the present event. And my lords, this is a serious point over here, because the question for consideration over here is, this was a event of a very massive scale. It had 50,000 people over here, and we need to point out with precision that who were the people who were constituting the unlawful assembly, to further proceed and to establish that if a shared common object did exist and if they were acting in concert.
Now, tell me, how do you then explain the wearing of the same kind of T-shirt with the same slogan by all the people, including the accused?
My lord,
Does it not show that there was a shared common intent then?
my lord,
Especially considering the fact that he was opposing, he had made certain statements previously also in that regard.
Yes, my lords. My lords, the accused individuals that were apprehended were indeed wearing T-shirts which bore the hashtag Lokina, my lords. And my lords, the hashtag Lokina means simply independence, my lords. There is a situation where all these people do have certain political dissatisfaction with the government, my lords. but them simply wearing a t-shirt which bears the hashtag Lokina on it, which simply means independence. It is just a way to express their political opinion, my lords. 92% likelihood that the appellant is the person. My lords, I would like to highlight the term likelihood over here. The report is not giving a conclusive identification that the appellant was the person who is assigned with the responsibility of committing the alleged act, my lords. And in addition to this, my lords, if you now turn to paragraph 4 of the document, same document, on page 11, the last line of this paragraph, my lords, in this line, my lords, the crime 360 report is itself conceding, my lords. The crime 360 report is saying that the crime 360 forensic analysis of the video indicates that @Neo MPR was either the person who shot the paintball gun or was standing next to him. My lords, again, the crime 360 report is itself not sure who the person is who is carrying the paintball gun.
Counsel, see, you may be right that you can't be convicted only on the basis of this report. But when you see the report in conjunction with other factors, that clearly establishes your guilt.
You know, the paintball pellets were found in your place. So then?
My lords, in addition to this, all the other evidence that has been provided is circumstantial, and it is not forming a complete unbroken chain, my lords. And it is a well-established principle that in cases of circumstantial evidence, a complete unbroken chain of circumstantial evidence needs to be established, which points only towards the guilt of the accused. Each of the circumstantial evidence, my lords, it's full of flaws and inconsistencies, and it is not able to discharge its duty beyond reasonable doubt, my lords. And my lords, answering to your question that paintball pellets were found at the accused's place, my lords, he was a paintball tournament player, my lords. He won a local paintball tournament 20 years ago, and he was a paintball player. So, my lords, it is we can assume that he has a reason to have paintball pellets at his place. It is not something that is very out of the. I'd like to just sum up and read.
Can we have a little silence here, please? A little silence, please.
The council seeks permission to address this entire bench as your lordships. Much obliged. Your lordships, this is counsel number 1 appearing for the state in the case of Mr. Yara versus State of Moda. The counsel 1 shall be dealing with issue number 1 and issue number 4, and my co-counsel shall be dealing with issue number 2 and issue number 3. This is purely because of the chronology of events that has happened. The first, there was a device which is called as a Crime 360 device that was introduced, whereafter 5 people were arrested for unlawful assembly. Hence, issue 1 and issue 4 is being handled by the first counsel. Then later on, the appellant here, Mr. Yara, was arrested at his residence and he was charged with murder, because of which the co-counsel shall be dealing with issue number 2 and issue number 3, your lordships.
I'm so sorry to interrupt, but you are on number
2541.
254.
Yes.
Thank you.
As your lordships are well aware with the facts of the case, the council would like just to brief regarding the AI tool that is being used in this particular case. The AI tool here is a Crime 360 tool which is used by the law enforcement agencies and the police to help them identify who the suspect is, and this tool compiled various databases that is available, including government records, biometrics, and individuals who are fined for violations, and anybody who wants to voluntarily apply for this particular app, their data is available here. The Home Ministry also has access to this data, and the Home Ministry has uploaded this data in their database, Your Lordship. Now, the appellant's data is available in this instant case because he was priorly fined for a traffic violation, and that has been mentioned in the clarifications, Your Lordship, that he was fined for jumping the traffic light, Your Lordship. So therefore, his data is available with the government, and it has also been used for for the purpose of Crime 360. Now, this tool showed a 92% likelihood that the accused is a perpetrator. He was arrested after the pellets were found in his house, and a paintball gun was also recovered after his confession, Your Lordship. Now, Your Lordship, so as mentioned, this tool contains, uses the database which is already available. So it acts as an assistant to the police and to the judiciary to help them arrive at a conclusion as to who the suspect is. The council would like to mainly contain here that this is a piece of a corroborative evidence and not as a direct evidence which the council expects the bench to use it as. To show that Mr. David Dhawan, PW 34, in his examination in chief and his examination in cross, if I may direct your lordships to paragraph number 15 and 16 of the Moot proposition. If you're with me, my lords, much obliged. Your lordship, in this Your Lordship, paragraph number 15 reads that in the course of the trial, the 360 was tendered as an evidence by PW 34 Inspector David Dhawan along with a 63 certificate. He testified that he is a trained technology expert, specially trained by the Luthra to operate the Crime 360 software. He testified while the complete basis on which the report was prepared could not be known, it had flagged some important inputs which led to the police to rely on it. He explained that the facial recognition match was run a second time with the facial print collected from the accused himself, and that returned for a 78% match with an incident footage showing the software to be accurate and reliable. So it is clear that it was not the first, that the IO did not rely on it the first time. A second time this was used so as to confirm the results, Your Lordship. So therefore, Your Lordship...
Tell me, it was the case of the appellant that the data set and the course and the source code was refused to the accused.
Indeed.
So these documents obviously were very important for the software operation.
Indeed.
So doesn't this denial strike at the very root of the prosecution case and vitiate the trial in that regard? And how can you even rely upon this then?
Your Lordships, in this case, the source code and database herein were not shared by the prosecution herein because it was not a relied upon material. Now, Your Lordships, the council would like to submit the compendium on behalf of the state. Your Lordship, in this case, the data set contains Your Lordship, in this case, the data set contains information of all the citizens of Ionia. There is so much of information about every single citizen there. So it is a matter of national security, which is the reason that that same cannot be shared to the other side, Your Lordship. So when such information is there, there is a high potential that this could be misused by anybody who had it. And if Your Lordships may look into the compendium page number 104, tag number 2, the council would like to rely on a very similar software that was used in the US, which was called as a Compass. It is a risk assessment tool which was used. In that tool, Your Lordship, in page number 103, Your Lordship, of the compendium, I agree with the majority opinion that the circuit courts may consider compass risk assessment with a multitude of other relevant factors at sentencing, as it was done in this case. If used properly with an awareness of the limitations and cautions, a circuit court's consideration of the compass risk assessment and sentencing does not violate a defendant's rights to due process. Similarly, in page number 104, the court denied North Point's motion to file an amicus brief over my dissent. North Point is the company which handles this Compass software, same as Looper Inc., which is handling this Crime 360 software. So when an amicus brief itself was proposed by the prosecution, which the court itself denied, saying that it is proprietary in nature and they are trade secrets, Your Lordship. So because of which this present source code and the data set cannot be shared to the defense witness, Your Lordship. If I may proceed, my Lord. Much obliged, Your Lordship. Your Lordship, next is regarding the allegation that this was a primary evidence under Section 57 of the Indian Evidence Act. The council would like to humbly say that all these informations is directly possessed by the Crime 360. It has been uploaded by the government only. There is no human intermediary who is involved in this, Your Lordship. And moreover, Section 63 permits the this evidence, electronic evidence, as a primary, even in the form of a printout which has been submitted in this case, if there is a certificate which the IO has also given, as mentioned, already read in paragraph number 15. So the device is also available with the IO, and that can be authenticated and verified here, Your Lordship. So therefore, there is no question of inadmissibility of the electronic evidence here, in Your Lordship.
Now, here I would like to ask a question.
Yes.
That during the cross-examination, PW 34 stated that this is the first case in which the suspect is identified using the Crime 360 tool. So then when, don't you think then this Crime 360 tool might have a scope for potential error, as the success rate of the said tool is not known as yet then?
Indeed, Your Lordship. There could be a possible error, Your Lordship, which is why this was solely used as a corroborative evidence along with the other evidences that was recovered, such as the pellets, the guns, and also the eyewitnesses that were there in the particular scene, Your Lordship. So this is why the counsel and the prosecution is fully aware that this is the first case in which it has happened, Your Lordship. And Your Lordship was absolutely right in pointing that same out. Okay. Your Lordship, regarding the statutory relevance, which can be pointed out in the Ionian Evidence Act, which is the present BSA, the council would like to mainly contend it on Section 6, 8 and Section 9 of the BSA, Your Lordship. Section 6, which shows evidence showing motive, preparation and conduct. Your Lordship, this particular device shows the past of the Mixo independence, which Mr. Yara wanted for separatism. He wanted to separate Mixolydia from the entire country of Ionia, and that has been shown through a past video which was shown in a platform called as a MySpace platform, Your Lordship. So this shows that he had a long-standing view of separatism here. So this shows that there could be a potential motive that he had in order to commit the crime, Your Lordship. Moving on to preparation, it is as pointed out, the crime forecaster analyzed his movements, his high anxiety, his facial expressions. All this indicated that there was some sort of a mental preparation which went behind a couple of hours earlier before committing this particular crime, Your Lordship. Moving on to the conduct. Moving on to the conduct, Your Lordship, the geolocation data, as mentioned, it confirmed his presence at the scene. So this also aligns with the time of the attack, Your Lordship. And moving on to Section 8, which is actions or statements by one conspirator can be used as an evidence against another if made in furtherance of a conspiracy.
Why do you have some water?
Thank you. Apologies and thank you so much, Your Lordship. In Section 8, Your Lordship, wherein the statements by one conspirator can be used as against another conspirator. Your Lordship, it's to be noticed in this case that the other co-accused have also been convicted by the trial court in this particular case, but it is just that their appeal is not being heard in this present stage. So therefore, that can also be used as an evidence against there. And Section 9, the facts which is otherwise irrelevant makes this relevant. So in a plain reading of document B, we can see that this entire thing wouldn't make sense because it is all past historical events there. But how it makes it relevant here is when all this is used in conjuncture with what has happened in that particular event, when read together, it makes all facts which is earlier irrelevant on its own now becomes relevant, Your Lordship. And there was also my co-counsel, my learned friend counsel had also talked about violation of the fundamental rights here in your lordship. It is humbly submitted that if there were challenging the fundamental rights violation, it has to be done in the form of a writ petition in this your lordship, and regarding the Ionian Criminal Identification Act. But since it has been challenged in this case, the council shall address it. Regarding right against self-incrimination, it has not been violated because the measurements were taken after there was an order that was given by the magistrate under section 5. The act also has a section 3 which says that which is the right to privacy of this particular person whose measurement is taken, that should also be maintained in this particular case. And that was also duly done, because only when the magistrate deems fit, he shall order this particular, for collecting this measurements, your lordship. So therefore, coming to the Puttaswamy judgment wherein they mentioned regarding the proportionality test, yes, your lordship, there is a legitimate goal to this, because it even though there is no preamble to this particular act, section 2 can infer that it was mainly for the purpose of protecting
held to take part in these investigative techniques against his own will?
In this case, your lordship, it was a case of a national emergency. The prime minister, the sitting prime minister of this country was attacked in this case, your lordship, because of which when there was a suspicion, the same bodily measurements was taken. And your lordship, it was taken a second time. The first time it was not, the first time already it was available as mentioned. But now a second time it was done so that it could be confirmed by them whether it was him or not. But it has finally led to the trial court to believe that he was the one who has committed this particular crime, your lordship.
See, gravity of offence cannot mean you can do something just because the gravity of offence is very high. It's prime minister doesn't mean that you can do something which is not permissible by law.
Your lordship, it is to be noted that the other group which was involved in this case is a neo-MPR group, and they have been banned for terrorist activities under, it has been found in paragraph number 3 of the Moot proposition that they have been banned for terrorist activity. So they are such a high-risk group of people, so therefore an additional security and a measure had to be taken to see whether Mr. Yara was also associated with this, and that came off as an affirmative which is going to be dealt by the council in the next issue of issue number 4, if your lordships may permit. Yes, yes, sir.
The 360 report is corroborative in nature. Why do you say it is corroborative in nature?
On
what basis did you in the first instance identify him?
Your lordship, in this, the crime 360 was used, and that result which it led to the police to start off an investigation and to find out in whether he was the person who perpetrated the crime, and they found out that yes, he is, because there was a pellet recovery in his house and a confession that was made which led to the finding of a gun in his house also.
How do you call that corroborative?
Your lordship, it was not the
What
sole
was the
reliance.
start point? How did you identify this gentleman?
Your lordship, the eyewitnesses in this particular case, PW4 and PW5, your lordship, they have placed him in this particular scene, your lordship. It can be inferred through...
No, please see your case, please see para 9. Who were the 5 individuals who were there?
Your lordship, Gauri
How did his
Lydia...
name
yes.
figure? How did his name figure as one of the accused?
Your lordship, there were 5 people which were who were arrested, but this was not an arrest which was made through the 360 report. This was the arrest which was made by the police who were present at that particular area. Now, Mr. Yara's arrest happened after what was found out in the crime 360. Yes, they went to his house, they questioned him, they found out pellets. That is when the police had a significant doubt as to, yes, there should be a gun if there is a pellet in this house, and which led to them finding out the gun after a confession was made by him, your lordship.
You agree that his name came up only as a result of the 360?
Indeed, your lordship, we agree to that completely. Your lordship, moving on to the last issue of issue number 4 regarding section 189 subsection 4, unlawful assembly armed with a deadly weapon. Your Lordship, the Council would mainly like to contend in this in a threefold manner. First is regarding the number of people, 5 or more people. 5, Your Lordship, it is to be noted that Yara and Neo MPR, they both have a same goal. Yes, only 5 people were arrested at first, but Mr. Yara was also present at the scene. The same can also be shown through the eyewitness who marked him there by saying that he, Your Lordship, that can be inferred in paragraph number 17 of the Moot proposition. Mr. Yara included, if your Lordships are with me, in paragraph 17. Other evidence adduced against Mr. Yara include the statements of PW 4 and 5, who attended the event, who stated that they saw Mr. Yara in a corner behind the crowd along with some other guys in a Mixolydian flag t-shirt. The cross-examination both admitted that they had neither seen or nor interacted with the accused in a person before the date of the incident, but volunteered that they could identify him based on his public TV appearances.
Identification parade carried out?
Your Lordship, the facts are silent on that matter, Your Lordship. Your Lordship, and at the same time there was also a doc identification which was done, wherein in the court both the PW4 and PW5 testified that it was Mr. Yara at that particular scene, Your Lordship. So therefore, in a very famous case of Kanta Prasad versus Rizagram, it is said that even if there is a TIP which has not been conducted, an identification in court is admissible in that case, Your Lordship. So therefore the eyewitness has placed him in that scene. Now there is also a CCTV footage. It can be seen that the present CCTV footage was, it can also be taken as a separate fact apart from this crime 360. And it is said that the CCTV footage was also signed by an officer who was in charge of the police department. So now the CCTV also shows him leaving his house in the afternoon of 4 June and returned at 8 p.m. approximately an hour after the incident. Your Lordship, it is to be noted that the tweet, which is the document G, Your Lordship, I think it would come as page number 18 in Your Lordship's proposition, annexures of the tweets that was made.
Yes.
Yes. Your Lordship, at 7:06 p.m., Your Lordship, the second tweet, at 7:06 p.m., Yara Mixol has posted, "Time to exit the stage and face the music, Diva Melody, Get Ing, Mixo 345, Tribal Rights Matter, Mixo Libera, Blackface is out." Your Lordship, that happened at 7:06 p.m., Your Lordship. And Your Lordship, at 7:01 p.m. is when the incident happened, and that 7:01 p.m. can also be inferred from the proposition of in page number 4, Your Lordship. It would be 4, paragraph number 8 of the proposition. The first line: on the evening of 4 June, as the finale of event was underway at 7:01 p.m., the commotion was caused. And exactly 5 minutes later, Mr. Yara also celebrates the success of what has happened, Your Lordship.
So is this evidence enough to suggest that there was a shared common objective?
Your Lordship, there is one more thing which is to be noted here, which is that the people who were arrested first, the 5 people, they were wearing a t-shirt which had the hashtag Lokina. Lokina in the Mixolydian language means independence. Now, if Your Lordships may come back to the tweets that was there. Your Lordship, 2 more minutes of extension. Much obliged, Your Lordship. If Your Lordships may come to the hashtags again, which is shown in the tweets, the last hashtag, which was the Lokina, that is also been shown here that it was used by the Neo MPR group, Your Lordship. So it shows that the same hashtag, which means that they wanted independence. And Mr. Yara also, he has been time and again, he had said that he wanted self-determination in this case. Now, Your Lordship, a small parlance to be drawn between self-determination and independence. Self-determination is when a specific group of people want a liberation or to stand up for their own country, and independence is the aftermath of self-determination, Your Lordship. For example, let us take the India-Pakistan separation, Your Lordship. In this, even though Pakistan wanted a separate state on its own, it later on proceeded to become they got independence from the entire country of India, Your Lordship. So therefore, that is what the prosecution would like to say would be the ultimate aim of Mr. Yara in this particular case, Your Lordship. Coming to my last, if Your Lordships are satisfied, coming to my last point of argument in this issue is regarding the possession of a deadly weapon, Your Lordship. The weapon which is being used by the appellant herein is the Tipman Brahmo 1 Elite paintball gun, and according to clarification number 95, this particular gun was brought from the US, and that also shows that it is for that specific purpose. There is no explicit definition for deadly weapon, but the Black's Law Dictionary defines the deadly weapon as any firearm other weapon, device, instrument, material or substance, whether animate or inanimate, which in the matter it is used or is intended to be used, is known to be capable of producing death or serious bodily injury, Your Lordship. So therefore, in this particular case, the serious bodily injury was caused to the commando, and therefore the prosecution rests its case on issue 1 and 4 on this, and my co-counsel shall proceed with issue number 2 and 3. Right. Much obliged, Your Lordship. It was an honor to argue before this bench.
All right.
Permission to address the bench collectively as Your Lordships. Much obliged, Your Lordships. May it please this Honourable Court, this is Counsel number 2 appearing on behalf of the respondents in the case of Mr. Yara Mixol versus State of Moda. Your Lordships, the Council will be dealing with two main issues. Issue number 2 and issue number 3 in the moot proposition, namely issue number 2 being whether the appellant, whether the conviction of the appellant under section 102 read with 105 is bad in law, and whether the appellant is liable for conviction of murder under section 103 clause 1 of the IPC. Your Lordships, for the purpose of the moot court competition, the Council will be referring to BNS, BNSS and BSA as IPC, CRPC and Ionian Evidence Act for this matter, Your Lordship. Your Lordships, to brief you on just this chain of events that happened, Your Lordships, on the June 4th of 2024 at 7:01 p.m. a paintball pellet was fired at the stage during a public rally, and this narrowly missed the Prime Minister, and this was at the head level, and it hit the backdrop banner, Your Lordship. Moments later, a second shot was also fired, and it hit the commando in the eye, who fell in front of the Prime Minister to save her life, Your Lordship. And ultimately, he fell into the crowd where there was already a stampede that was ensuing, and he succumbed to death due to the injuries that he faced due to the said stampede, Your Lordship. Now, as my co-counsel mentioned, the Crime 360 report gave a 92% likelihood that Mr. Yara Mixol was the one who committed this instant crime, Your Lordship. And upon this likelihood, the police raided Mr. Yara here, in Your Lordship.
Just a question here.
Yes, Your Lordship.
See, the prosecution witness number 53 had stated that a detailed description of the gun was given by Mr. Yara, which was not included in the written statement. That's
Yes,
which is there. So then how could then the recovery which you just referred to from be trusted, since pointing out memo, like this document 2 and the recovery memo do not mention as such with respect to the gun, the details of the gun as such, then how do we correlate the same?
Your Lordships, it's pertinent, the Council is well aware of the fact that confessions are not admissible in this court, Your Lordship, where it was made in front of the police officer. But part of the confession, by the save of the proviso under section 23, can, if it leads to the discovery of a material fact, it could be admissible. That is what has happened in this instant case, Your Lordship. If Your Lordships may look at the confession in document number E, the last line reads, "I can recovered the gun from the road on which I disposed of it if taken there." Your Lordships, the council is aware that past events cannot be a matter of admission of, cannot be admitted in this court of law, Your Lordship. But the part of the sentence that says that if I am taken there, I can recover it or I can point it out can be admitted, Your Lordship, and that can be admitted when the fact is proven by the said recovery of the weapon, Your Lordship, and that has happened in this instant case, Your Lordship. Now, firstly, Your Lordships, if we were to reprise the chain of circumstances that have been established by the trial court by the prosecution, number one is the prosecution witness number 4 and 5 who have placed Mr. Yara Mixol at the crime scene, Your Lordship, who was found speaking to four or five other people. Your Lordships, herein it's pertinent to note that doc identification is a substantive part of evidence, Your Lordship, and while the test identification parade has not been carried out, it's pertinent to note that the test identification parade is only required to be conducted when the witness is not acquainted with the criminal, with the accused, or when there's no reasonable reason for the witness to remember the appellant, Your Lordship. Herein both have been satisfied, Your Lordship, and this is because Mr. Yara Mixol is somebody who is a radicalist. He is known to the entire community. He is a social figure, Your Lordship, who has time and again wanted radical separatism, and he has and the same has been evidenced in the Moot court proposition. So it's well aware. It's a well-established fact that the prosecution witnesses were well aware of who Mr. Yara Mixol is and what he looks like as well. Your Lordships, if we were to look into the second chain, that is the recovery of the pellets, Your Lordships, the council would like to clarify certain irregularities as pointed by my learned opposing counsel, Your Lordship. Your Lordships, it's pertinent to note that minor irregularities do not vitiate the entire proceedings. When it does not affect the root of the case, it could not lead to a violation of right to fair trial. And herein, there is only a lack of independent witness signatures with regards to the paintball gun. And with regards to the pellets, yes, there was no audio-video recording that has been done, but that is a curable defect, Your Lordships, and the same has been laid down in the case of Iqbal Ismail Sodawala versus State of Maharashtra, wherein the Supreme Court in itself has held that the Code of Criminal Procedure is in existence for the procedures to be followed, yes, but not in the most stringent way that it completely takes away the prosecution's case by the vice of the irregularities that have been met out by the side, Your Lordship. Additionally, the fourth chain, that is the digital evidence, that is the Crime 360 report, wherein the geotags, wherein the CCTV footages that has seen Mr. Yara Mixol leave his house in the afternoon and come back at 8 p.m. with anxiety on his face, showing that he has done and committed a crime that he is going to get caught for. And all of this conclusively points to the fact that Mr. Yara Mixol was the one who committed the crime through this said chain of circumstances. Additionally, Your Lordship, there was also the social media footage that was recovered, wherein it was shown that a black masked individual was pointing a gun towards the stage only seconds before it was fired, Your Lordship. It's pertinent to note herein that when Mr. Yara Mixol's face was taken as a print as per the Ionian Criminal Identification Act, the procedure was followed here in Your Lordship, and it was run through the Crime 360 report, and where the match was shown as 78%, this corroborating with the prosecution witnesses' statements, it can be conclusively proven that it was in fact Mr. Yara Mixol who was at the crime scene, and it was in fact Mr. Yara Mixol who was wearing the black sweatshirt, and that he was the one who used the paintball gun to kill the Prime Minister, or attempted to kill the Prime Minister and ended up killing the commando in the process, Your Lordship. This only comes, Your Lordships, this only comes to the point of the ingredients that have been established herein. Your Lordships, Section 102 talks about the doctrine of transferred malice, Your
No,
Lordship.
yes.
Yes, Your Lordship.
So now tell me, section 63(4) of the Evidence Act says that whenever you are relying upon the statement in evidence, then for doing that, identifying the electronic record containing the statement and describing the manner in which it was produced and giving such particulars of any device. So in here, when such details have not been furnished with respect to the particulars of the device involved, then how do you say that this crime 360 report satisfy the ingredients of the Evidence Act then?
Your Lordships, herein it's pertinent to note that the manner in which the information has been culminated by the crime 360 report is merely a culmination of facts that has been given before the Honorable Bench, Your Lordships. This is not a conclusive proof or a matter of importance to take into consideration that it is the sole reason why Mr. Yara Mixol has to be convicted. But rather there are several other chains of evidences that I had established herein that has to be looked into along with this one part of the chain, which conclusively and unequivocally points to the guilt of the appellant here in Your Lordships.
No, but tell me, is there a report which says that this pellet injury was the cause of the death?
Your Lordships, in the clarification it has been given that the cause of the death, that is the post-mortem report that has been given, says that there was a subdural hematoma, there was asphyxiation, and there was also trauma to the head. Your Lordships, this brings me to my argument that the death was not caused by the pellet in itself, but it was because of the stampede that was caused due to the shooting of the pellet that led to the chaos that ensued in the crowd, Your Lordship. Your Lordships, it's pertinent to note that where a weapon such as the Tipman Bravo gun, it looks like a military gun, Your Lordship, and the same when used in a politically charged event with more than 50,000 people who are present there, if it is shot, it would lead to panic, it would lead to chaos, and ultimately any prudent man would have the knowledge that it is likely to cause death, thereby satisfying the first ingredient of section 100, Your Lordship. And additionally, the ingredient of actus reus herein has also been established by his presence at the crime scene and his usage of the paintball gun and him shooting the paintball gun at the Prime Minister and ultimately hitting the commando instead. This only brings me to my next limb, that is this satisfies the doctrine of transferred malice, Your Lordship. Your Lordships, in the case of Nanhe versus State of UP, or even a fair reading of the provision and the illustrations, it says that there has to be an initial intent in order for it to be transferred to the person who actually got killed. And the same has been established herein in the form of the knowledge that the appellants had possessed in this instant case, Your Lordships. Your Lordships, if the bench is satisfied, may I move on to the next issue, Your Lordships? Much obliged, Your Lordships. Issue number 3, with regards to whether the appellant is liable for conviction under section 103 clause 1 of the IPC. Your Lordships, the first ever ingredient for proving murder is to prove culpable homicide, and the same has been established here in Your Lordships. Your Lordships, the council would like to draw a small line of difference between culpable homicide and murder, and why this does amount to murder. If we were to give a fair reading of section 101 clause D, it says that where a person does an act that it is so imminently dangerous that it must in all probability cause death, or such bodily injury that it is likely to cause death. Your Lordships, and despite this knowledge, he committed this act without any excuse for incurring the risk of causing death or such injury as aforesaid, Your Lordships. Your Lordships, it's pertinent to note herein that Mr. Yara Mixol is a trained paintball player. He is endowed with the knowledge that if he stands from what distance, at what angle if he shoots from the crowd, will it cause panic? Will it hit the Prime Minister? And will it ultimately cause the death of the Prime Minister as what he had intended to?
So you think the intention was to cause death on account of panic and stampede, or on account of direct hitting the paintball pellet?
Your Lordships, the council humbly submits herein that Mr. Yara Mixol was completely aware of the fact that the shooting of the paintball gun would ultimately lead to chaos, and that would lead to stampede. And if Mr. Yara Mixol hits a person on the stage with a paintball gun, in that force the person would definitely fall into the crowd, your lordship. And any prudent man would know that. And due to the stampede, at least some amount of injury that would ultimately lead to death would definitely happen. And that is what has happened in this instant case, your lordship.
Tell me, was the pellet gun capable enough to cause an injury which could cause death?
Your lordships, the pellet in itself could not cause death, your lordship, but the act of shooting a paintball gun that looks like a military gun in a politically charged event is what has led to the death ultimately, your lordships. Is your lordship satisfied?
Proceed.
Much obliged, your lordships. Your lordships, so in simple terms, your lordships, the culpable homicide becomes murder when the person knows that their act is so dangerous that in all probability that would cause death or serious injury, and still proceeds with it without any excuse, your lordships. And the same has been used. Your lordships, Mr. Yara knew and understood that his actions was likely to cause death and result in death or even severe bodily injury as it has happened in this instant case, and yet he committed the act without any justification. And this behavior squarely falls under the section 101 clause D, and therefore Mr. Yara Mixol has to be convicted for murder under this case and be sentenced for life imprisonment, your lordships. Additionally, your lordships, with all the other circumstantial evidences that the trial court has replaced and this prosecution has established, it has been proven beyond reasonable doubt that yes, Mr. Yara Mixol is in fact liable for murder under section 101 clause D, your lordships. Your lordships, with this, the council may move on to the prayer, your lordships. Wherefore, in light of the facts stated, issues raised, arguments advanced, the authorities cited, it is most humbly and respectfully prayed before this Honorable Court, High Court of Moda, that it may be pleased to uphold the conviction of the appellant for the offences under section 101 read with 105 and 189 clause 4 of the Ionian Penal Code, and also convict Mr. Yara Mixol under section 103 of 1 of the Ionian Penal Code, and pass any other order, direction or relief that it may deem fit in the interests of justice, fairness, equity and good conscience. It was an honor arguing before your lordships. Thank you.
Is it okay now? Lords, may I proceed with the rebuttals?
Yeah.
So, Lord, it's very unfortunate to point out that the prosecution, they have misled this court on the facts of the case as well as law, Lords. As regarding the facts, Lords, they mentioned that Neo-MPR, which Mr. Yara was a part of, it was a banned terrorist organization. Lords, the facts do not say so. The preceding organization, which was MPR, that was banned for terrorist activities. No adverse action has been taken against NPR so far. So to claim that it was also banned for terrorist activities is just to mislead my lords.
Isn't that only a handle at Neo-MPR?
Lords, it is a
social media handle. It's been linked to Mr. Yara.
Lords, Neo-MPR, it is a youth organization.
Yes, but apparently what the report seems to suggest is that Mr. Yara is the one who's operating the account, the social media account of at Neo-MPRER, which has also given the live feed of what has happened.
Yes, Lords.
That seems to be what this fact suggests.
Lords, but if my Lords may refer to the tweets, they were also posted from Neo-MPR's account. Lords, as per the Crime 360 model, Neo-MPR is indeed the person who was, Neo-MPR is Mr. Yara only, as per the Crime 360 report. But my Lords may notice that at 7 p.m. exactly on the day of the incident, just 1 minute before the shooting of the pellet, Mr. Yara was posting a tweet as per the Crime 360 report. Lords, at such a packed gathering where he wanted to kill the Prime Minister, at 7 p.m. he was posting a tweet, at 7:01 p.m. he shot the pellet, and then again at 7:06 p.m. he was he was posting tweets again. So Lords, that itself raises discrepancy and how the tweets could not be relied upon, Lords. And further, a Section 63 certificate was also not attached with the tweets. Lords, furthermore, Lords, a TIP was not conducted in this case. It is very well mentioned in the clarifications. Lords, now coming to the point of law, Lords, the prosecution submitted that a paintball pellet gun may qualify as a deadly weapon, because when we speak about 189 subsection 4, we need a deadly weapon. Lords, but there is a difference between pellet guns and paintball pellet guns. Paintball pellet gun was the one used in the present case. And I would be explaining this difference because pellet guns, Lords, they have metallic pellets, which if they are if someone is hit by them, they can cause severe injuries which may lead to death. Whereas a paintball pellet gun, Lords, pellets, they are made up of soft materials such as gelatin or water-soluble substances. And inside that, paint is stored. So whenever a pellet is shot towards someone, the pellet bursts and paint explodes. Lord, that was the nature of the weapon that was used. And as regarding the specific model of the gun that was used, Lords, it is easily available on websites. Even I can order one for me right now, and it requires no licensing, Lords. It is used in arcade games where even children play with protective gear, Lords, but it is not a deadly weapon. It cannot lead to an injury that would cause death. Lords, regarding the point of the AI model being allowed to operate and the fact that they are fitting it within the ambit of the Ionian Criminal Identification Act, Lords, to assist my Lords, I would submit that in other countries also AI models are being used. But Lords, all of those countries, they have certain safeguards and certain guidelines for their AI models to follow. So all that I submitted was that till the time there are guidelines, there are safeguards which the model could abide by, till that time the report should not be admissible, Lords.
The Act of 2024 itself allows that measurements can be taken and then can be relied upon. Then obviously the admissibility of the evidence then cannot be challenged then. When the statute itself is allowing the same.
My lady, the Act is merely limited to measurements. But the Crime 360 model, it is not operating on only measurements. That is just one part of the model. It is also operating on other data which the Act is not permitting, my lady. My lady, as regards to the point of recovery, may I seek an extension of just 2 minutes? As the points regarding recovery, the prosecution submitted that it is a mere irregularity, that independent witnesses were not joined. But and the cases that they relied upon, I would like to point out that, my Lords, the courts have ignored the requirement of independent witnesses only in those cases where the investigating officer had made an effort to make people join the investigation, but they were not able to do so. That is when they ignored. But in the present, order to join the public witnesses to effect the recovery. Furthermore, my Lords, no description of the weapon was also given. It was also recovered from a public place. So had there been just one irregularity, we could have ignored it. But the case is full of irregularities, and all the defense has to do is raise a reasonable doubt in my Lords' minds. Lords, as regards the requirement of knowledge, which is required under Section 101 Clause D, that is knowledge of all probabilities. But my Lords, it is not a foreseeable consequence that every time a stampede happens, a death would occur. My Lords, a few months ago, President Donald Trump, he was also shot during his rally. But in that present case, no stampede occurred, my Lords. So that just proves that the knowledge under culpable homicide itself is not established. So how can the knowledge of that is required for the offense of murder can be established? Lords, as regarding the presence of enough circumstantial evidence, Lords, when there is absence of a direct evidence, then it is required that all the circumstantial evidence that is placed on record, it must form an unbroken chain of events. But here, each of the circumstances is disputed, Lords. The recovery is disputed, the Crime 360 report is disputed. So a reasonable doubt is created in the minds of my Lords, and the benefit of that should be given to the accused, Lords. So grateful.
inside this seminar hall because the judges will come back after they're done with scoring for a feedback. Thank you so much.
आया, पहले नहीं आया था. A huge round of applause for the chief guests and our guests of honor, ladies and gentlemen. I request everyone to kindly take their respective seats. A very resilient and resonant good evening and a warm welcome to all the prodigious people present in this August gathering. I heartily welcome you all to the prize distribution ceremony of the 21st KK Luthra Memorial Moot Court 2025, organized by the Moot Court Society of Campus Law Center, Faculty of Law, University of Delhi, in association with the Nirmal Luthra Foundation.
A special welcome to our chief guest for the day, Honorable Mr. Justice Abhay Srinivas Oak, Judge Supreme Court of India, and guests of honor, Honorable Mr. Justice Amit Bansal, Honorable Mrs. Justice Mini Pushkarna, and Honorable Mr. Justice Harish Vaidyanathan Shankar, Judges, High Court of Delhi.
Now, without further ado, I request the Professor in charge of Campus Law Center, Professor Dr. Gunjan Gupta, to come to the podium and deliver the welcome address.
Thank you, Sunny. A very warm good afternoon to you. Honorable Mr. Justice Abhay Srinivas Ok, Judge Supreme Court of India. Honorable Mr. Justice Amit Bansal, Judge High Court of Delhi. Honorable Ms. Justice Mini Pushkarna, Judge High Court of Delhi. Honorable Mr. Justice Harish Vaidyanathan Shankar, Judge High Court of Delhi. Members of Luthra family, Mr. Siddharth Luthra, Mrs. Ketki Goswami, Dr. Meera Luthra, Dr. Geeta Luthra, and esteemed dignitaries, respected faculty members, and dear participants. It gives me immense pleasure to welcome you to all to this valedictory and prize distribution ceremony of the 21st KK Luthra Memorial Moot Court Competition 2025. Honorable Mr. Justice Oak, Judge Supreme Court of India, has kindly accepted our invitation to grace this event as the guest of honor. He is an embodiment of kindness and erudition. Sir's focus on elevating sufferings of victims according to importance of work done by Anganwadi workers while advocating a more humane and approachable judiciary has allowed for a discussion of better access to judiciary by the common persons. Thus, advocating the importance of district and taluka courts, Sir has, during this illustrious career, has been a part of numerous important cases and has made a mark on the Indian legal system, both as a judge as well as a member of the bar. A huge round of applause. Sir, I welcome you. Honorable Mr. Justice Amit Bansal, Judge Delhi High Court, specialized in different forms of dispute resolution, including commercial, business litigation, international commercial arbitration, employment and property disputes, consumer disputes, and disputes relating to companies, including intellectual property rights. Justice Bansal has brought to a fore a very important learning for our students to understand and appreciate all the nuances of the law to be a successful legal practitioner. Thank you so much. Welcome you, sir. A huge round of applause. Justice Mini Pushkarna, Judge, Delhi High Court, being elevated, had over 25 years of experience as an advocate at the bar, during which period she has been the standing counsel for various bodies, including the Municipal Corporation of Delhi, Delhi Urban Slum Improvement Board, and has been on the panel of Services Department of the Delhi government. Justice Mini's expertise with the urban local bodies and her experience with the people at grassroots and understanding of their sufferings has made her a renowned legal personality and earned her the name Judge with a Heart. Thank you, ma'am. Honorable Mr. Justice Harish Vaidyanathan Shankar, Judge High Court of Delhi, is a proud alumnus of Campus Law Center, Faculty of Law, and has been a part of various important technical cases during his lifetime as an advocate. His expertise in cases like the Navy room leak case, as a public prosecutor in Godhra rights case, and Army service matters has led to the creation of remarkable scholarship. His academic scholarship as is visible from his study at Warwick, coupled with practical training in complex matters, makes him an ideal mentor for the law students. I welcome you, sir. An event of this magnitude requires a support and cooperation which we are lucky to receive in the form of endowment and trust from the Luthra family. I am grateful to all the relatives and friends of the Luthra family who have always graced this event and made it even more august with their presence. Thank you for this. This edition of the event was even more special because it marked the centenary birth anniversary of late Shri K.K. Luthra ji, in whose loving memory this event is hosted every year by the Campus Law Center in collaboration with the Nirmal Luthra Foundation, established in the loving memory of late Shrimati Nirmal Luthra ji, wife of late Shri K.K. Luthra ji. I also welcome and at the same time thank all the participating teams consisting of 216 participants from 10 different countries who have traveled across the globe to participate in this illustrious event. We had started the tournament with just 18 teams in the first edition of the event, and now we have grown to 72 national as well as international teams. I thank each of the participating teams for participating in this event, making it a huge success. A huge round of applause for them. Since we all are waiting for the results and the prize distribution, I also would like to say I congratulate the winners, whosoever they are, on their success, but would like to add that for me, each of the teams that participated are winners, as they are going back with experience which will be surely helping them in their future endeavors. And good luck to them. We got to witness extremely engaging and thought-provoking argumentation and courtroom exchanges over the course of the past 3 days. I am elated to share that with the smooth functioning of the 5 layers of rigorous adjudication, enthusiastic participation of the teams, and tireless hard work of the organizing committee, the whole tournament was a huge success. And it was only because of the tireless hard work of the organizing committee. A huge round of applause for them. The success of this program would not have been possible without the relentless efforts of the Moot Court convener, Dr. Suman Yadav of the Moot Court Society, and her team comprising of the members Dr. Rubina, Dr. Vijoy, Dr. Mehpara, Dr. Rahul, Ms. Apanjot. They also need to be applauded for that. Also, the acknowledgements are due to the whole organizing team of the Moot Court Society of the Campus Law Center of 26 members, along with their valuable assistance of 300 plus volunteers who put their heart and soul in the proper functioning of the event. Ladies and gentlemen, I want a huge round of applause for them. It is not much to say that these organizing committee members have burned the candle at both ends to bring this event to a glorious culmination. A very, very big hands for them once again. And I wish that this continues years to come. Thank you so much, everyone, for being present here. Thank you. Over to you, Sandra.
Thank you so much, ma'am, for your motivating words.
Now, I request ma'am to kindly stay back and also invite Dr. Meera Luthra to come up and felicitate our chief guest for the day, Honorable Mr. Justice Abhay Srinivas Oak, with a token of our appreciation and gratitude.
Thank you very much, ma'ams. Now, I request Dr. Rakesh Khazanchi to ascend the stage and felicitate Honorable Mr. Justice Amit Bansal. A big round of applause for sir, ladies and gentlemen. Thank you so very much, sir.
Now, I request Dr. Geeta Luthra to come up the dais and felicitate Honorable Mrs. Justice Mini Pushkarna.
A huge round of applause.
Thank you so much, ma'am.
Now, I would like to request Mrs. Ketaki Goswami to ascend the stage and felicitate Honorable Mr. Justice Harish Vaidyanathan Shankar. A huge round of applause for sir, everyone.
Thank you so much, ma'am. I request Honorable Mr. Justice Amit Bansal to share his feedback with the participants.
Regarding the final rounds which he adjudicated some time ago. I request, sir, a round of applause for sir, everyone.
First of all, I must say it was very heartening to note that both the finalists were represented by an all-girls team, which is absolutely fantastic. The second observation to make was that I think both the teams, the speakers, the teams were brilliant. The level of preparation was quite outstanding. It just reminds me of my days as a student, as a law student, and when we started these moot courts, the preparation was quite in an amateurish manner, but now the level is quite unrecognizable from those days. So fantastic, great job done by both the teams. The difference between the two teams was so narrow, and both the teams performed brilliantly. So the only observation I'd like to make is that, of course, you're all upcoming lawyers and you'll be sooner or later practicing. So please prepare your cases with utmost sincerity, go into the depth of the matter. You never know what a judge may ask, and never be rattled by the questions put by the bench, because no matter, we've all been lawyers, so we know, no matter what level of preparation you have, you can never predict the questions which will come from the bench. So your ability as a lawyer is how you handle them in the best possible manner. But anyway, good luck to all of you, and I'm sure you're going to make very successful lawyers.
Thank you so much, sir, for your valued feedback. Now, I request Honorable Mrs. Justice Mini Pushkarna to kindly share with us her feedback. A round of applause for ma'am, everyone.
Good evening, Justice Oak, my brother judges, students, ladies and gentlemen. It was a great experience to hear these young girls speak so well, and I know that the future of law profession is really great. As far as mooting competitions are concerned, I would say that this is such a beautiful way to not only learn the ways of the law. As students, you would get the practical first-hand experience as to what to expect when you appear in actual courts of law, the kind of questions that may be posed to you by the bench, and the kind of preparation you must have. And the kind of whatever I heard from the students, it was really wonderful, and I congratulate both the teams. And as far as this profession is concerned, law profession is such a dynamic profession, and lawyers, persons from legal profession, they've always been in the forefront in the society. Right from our freedom movement, the first Prime Minister of the country, all of them have been lawyers. So the profession which you have chosen is not only a profession which will open many doors for you, but will also make you a responsible citizen, because you would be at the forefront of in the society as upholder of the rights of the common man in the society. And the kind of experiences which you would have as a lawyer, as a legal professional, this will help you not only earn your money, but also make you a good human being, have a kind heart for the problems which the common man faces, and also do your bit for the common man. And I wish best of luck to all the students who are present there. I'm sure that all of you have a bright future. The sky is the limit with the hard work that you will put in. Thank you so much.
Thank you so much, ma'am. Now, I kindly request Honorable Mr. Justice Harish Vaidyanathan Shankar to share his feedback as well with the participants. A huge round of applause for sir.
Good evening everyone, and firstly I'd like to thank the Luthra family for having me over as a judge. Then the second and most important aspect, which I believe is the subject itself and the topic and how pertinent it is to today's day and age. AI and the way it is kind of going to become all pervasive in the days to come. I think it's about time we considered not just the interaction of AI in the kind of crimes that we're talking about here, but at a certain point where crimes, there are going to be more crimes being committed online itself, and that we're already seeing in so many different ways. So I think as a subject, this has a lot of relevance, and I must compliment whoever thought of it. It's a very pertinent subject. And of course, as everyone has already mentioned, the fact that there are so many ladies present over here, and the fact that litigation, I still remember when we were students. Of course, I'm the youngest of all the judges over here, but when I was pursuing, litigation as a choice for the ladies was not something which was very preferred. It was more of people getting into companies, or as a lady, litigation was sometimes not really the most preferred option for lady lawyers as such. And I'm happy to see that the Luthra family and they are promoting such kind of moot courts and everything where ladies are able to participate, and I'm sure you'll take it forward and in the profession do really well. And I wish you all the very best for that. Thank you. Thank you.
Thank you so much, sir, for your valued feedback. I now request our chief guest for the day, Honorable Mr. Justice Abhay Srinivas Oak, to approach the podium and enrich the audience with his thoughts. A huge round of applause for sir, everyone.
Sister and brother judges of Delhi High Court, the faculty members of Campus Law Center, academic staff, Mr. Siddharth Luthra and family members of Luthra family, young students. Normally, I do not accept invites to attend moot court competitions, but I accepted this invitation for 2 or 3 different reasons. First and foremost is that Campus Law Center is one institution where boys and girls from middle class can afford to join law course because the fee structure is so reasonable. There are very few leading institutions, leading law colleges in our country where you can get law education at such reasonable fees. I always remember my own student days when I joined Government Law College in Mumbai in 1980. The first year LLB identity card I have still preserved for different reasons. I kept it in my house in Bombay, otherwise I would have showed it to you. The first semester fee was rupees 123 and second semester fee was rupees 89. Of course, those are the days where we were supposed to have 3 lectures in a day, and hardly we used to have 2. And I don't think I should be telling how many lectures I attended. But Government Law College was just such a place. There were 3 very eminent institutions very close to the Government Law College. One was, of course, Bombay High Court. The second one was British Council Library. It was a huge library near LIC building, where in 1980 and 81, we could read books on all subjects, and they used to show beautiful video films, which was not available anywhere else. And the third institution was Wankhede Stadium, where we could purchase ticket worth ₹1 and see Gavaskar, Vishwanath in action, and many great players we could see. And proximity to Bombay High Court was a great advantage, though there was hardly any teaching in those days. The proximity was because we could see greats in action. I remember as a student, I have seen great H.M. Sirvai arguing before a full bench of the Bombay High Court. But of course, I must confess that I did not understand what he was arguing because I was a first year student at that time. But that was a great advantage to see Palkhiwala arguing. I have seen Palkhiwala arguing. And those were the days where there used to be hardly any moot court competitions. I remember in Government Law College, there used to be hardly 1 or 2 moot court competitions, and we had not heard anything like mock trial competitions or any other, hardly any competitions. So advantage was frequently we used to get very good guest lecturers. I remember Palkhiwala was called to deliver a lecture. Great MC Chagla, he was not able to walk also. I could hear his lecture. But thereafter, from 1990s onwards, the law education has become completely different. In 1980s, still 1980s or till 1990s, when 5 years course started, popular misconception was that those who could not secure admission to any other professional course, as last resort, they used to join law colleges. Because in those days, getting admission in law colleges was very easy. Now things have changed. And from 1990, there was a huge change in legal education when we had 5 years course. But with all those national law schools coming, private law schools coming, according to me, thinking about legal system in India, the most important institutions which teach law are like campus law center or ILS law college, government law college, where affordable education in law is available. Because if you see the legal history of India, the stalwarts have come from middle class families or lower middle class families. See, Palkhiwala was from a very poor family. So we need such institutions if you want to strengthen the legal education and strengthen our legal institutions, the institution of judiciary. One very important change which I have seen after I became a judge. I was chairman of the recruitment committee of Bombay High Court. I was chief justice in Karnataka. During last 7 to 8 years, what we have noticed is in all judicial appointments we make, civil judges or district judges, now more than 50% of judges are women. And that's a huge change we had. I have seen, I went to Bihar Judicial Academy about 2 years back. There are about 300 recently appointed judicial officers. 63% of them were women. Now this is a major change which we have seen, and as sister and brother said, wherever you go to any moot court competition, now you will find the winners are girls. The boys are an exception. Very rarely we see young boy winning moot court competition. So that was the first reason why I accepted the invitation, because it is campus law center. The second reason was, of course, it is in the memory of late K.K. Luthra. And his story of his life is so inspiring. He had to come from Pakistan after partition. He started in trial court, and I believe that he was one of the greatest trial court lawyers, though he had large practice in High Court and Supreme Court. Because I started working in trial court with my father, I worked for about 2 years. Therefore, I get fascinated when somebody who started his practice in the trial court becomes such an eminent lawyer. And very curiously, I read somewhere that he was a civil lawyer, but later on he achieved eminence in criminal law. But basically, he was a civil lawyer. And the third reason why I accepted this invite was because of the very name itself, because this institute has given great judges and great lawyers to our legal system. And today also, my dear colleagues are there who are product of this institution.
So Campus Law Center.
Right. So not only that there is affordable legal education here, this institution has given great judges and lawyers to the traditional legal system. I'm emphasizing on traditional legal system. I'll emphasize that little later. I used to have some reservations, still I have reservations on the manner in which moot court competitions are conducted. And the reservations are about the subjects chosen. Today, of course, this is a different competition because here's an international moot court competition. Otherwise, in Indian law colleges or our national law schools, where the competition is confined to law schools and colleges in India, we see some international law subject, private international law, public international law, subject on British law, American law, or some very complex issue of intellectual property law. If we need to give real benefit of moot courts to our students, we should pick up a paper book of civil appeal arising out of a civil suit, maybe pending in the High Court, or a criminal appeal, and modify it to some extent and conduct moot court competitions on these subjects. Because if you give a civil appeal to argue, then student will understand the importance of pleadings, how to read the pleadings, how to appreciate whether a particular document is admissible in evidence or not, what is hearsay evidence, and ultimately how do you read the evidence. Same is the case of criminal law. Today, sadly, I find some of the lawyers practicing in Supreme Court also. They don't know what is the meaning of contradiction and what is the meaning of omission. So we need to train our students on these basic laws, because I believe, I always say this, I have said it openly as Chancellor of National Law School also. In fact, in National Law School, where I am Chancellor, I always tell the students that, look, the entire setup has come up from the government funds, and therefore we expect the students to give back something to traditional legal system. We must encourage young students to join traditional practice before the trial court, before the High Court, and before the Supreme Court, at all fora. The reason is that we need good lawyers to practice in our traditional courts. We need some bright minds, bright young minds to think of joining judiciary. We need really we need talent in our judiciary. So in national law schools where I am the chancellor, we always encourage the students, 3rd year, 4th year and 5th year, to participate in the entrance exams for judicial appointments. Because I want to tell with great deal of emphasis for the benefit of young students. Sitting in Delhi, sitting in major cities like Bombay, Bangalore, we talk about so-called commercial litigation. The so-called commercial litigation, arbitration litigation, IPR or IB court, this doesn't constitute even 5% of the total litigation in India. The main litigation in India continues to be traditional litigation before our trial courts, high courts and Supreme Court. And one more thing which I want to tell for the benefit of young students, don't consider practice before the trial courts as something which is insignificant. I want to tell with great deal of emphasis that the most important courts in India are our trial courts, where people file pleadings on the civil side, or the basic cross-examination of the accused is conducted in the trial courts. If the cross-examination is not conducted of the prosecution witnesses, nobody can help that accused in the higher courts. So it is very, very important that all of you should think about practicing in trial courts. I'll give an example of a great lawyer I have seen. I have seen his performance in Bombay High Court, Ram Jethmalani. Mr. Ram Jethmalani used to appear before magistrates' courts in Mumbai very regularly. He used to conduct trial in magistrates' court. I know I had briefed him one of the matters. I had accompanied an attorney to his office, and he said that, look, I can't understand this, why people consider practice before the trial court as inferior practice. Because he said, every court is important for our legal system. So therefore, with great deal of emphasis, I want to tell the young law students that please consider of joining the mainstream practice, that practice before our courts. And some of you must also aspire to become judges. I want to tell you for your information, now after former Chief Justice's judgment, somebody who enters our judiciary as a civil judge at the age of 26 or 27, he is paid much more than what IPS or IAS officer gets from his day one. The conditions of service are far better as compared to what we are doing about 20 years back or 25 years back. This is what I want to tell that. And third and most important thing, that I find after 20 years of practice and 20 years of judgeship in constitutional courts, that in our country, in true sense, there is hardly any legal research. The legal research takes place only for submitting theses for obtaining doctorate. But in true sense, there is no legal research. And fourthly, now we have so many law colleges coming up, so many law schools coming up. We need quality law teachers. So that is also one career which the students must consider, because we need good teachers. Because go to any law school, there is dearth of good teachers, because we are not getting sufficient number of teachers. So first is come to trial court practice. Some of you must think of joining judiciary, and some of you must think of becoming academicians in true sense. Now coming to the moot court, I am sure that some of you will be joining traditional legal practice, but there is a vast difference between moot court and a regular court. You must understand the difference between the two, because sitting in High Court and even sitting in Supreme Court, sometimes I have to tell the young lawyers appear before me that please forget your moot court days. This is not a moot court. This is a regular court. And you know, you have to be good in law if you want to practice successfully. You have to be very well prepared on facts, but you will never succeed in the profession unless you know what is art of advocacy. It is expected of you that you will be very ready with your brief, you will know facts, you will know law, but unless you have art of advocacy, you will not succeed in the profession of law. And please remember one thing, you know, people say that art has to be inborn, but this is one art which need not be inborn. This is one art you can learn, and you can learn by sitting in the court right from 10:30 to 5 o'clock or whatever is the court time. You will learn this art by seeing greats in action. This is something we will learn from seeing performance of the lawyers. This is something which you will learn as you start appearing before the court, because art of advocacy is most important for you. And see, what is ultimately art of advocacy? For that, you'll have to consider only one question. What is the duty of a lawyer? Now, duty of a lawyer is to convince the judge that his client has best possible case. That's the basic. You have to convince the judge that your client must get the relief from you. That's the object of advocacy. And you learn the art of advocacy when you learn the art of thinking on your feet. See, when you appear in moot court, nobody is going to ask you awkward questions. And you go with preconceived notion, you make preparation, you work very hard, and then you argue before a moot court. But in real court, that will not work, because in real court, the judge will ask you several questions. If you have five points in your mind, that they are the best points you want to argue, the judge may not be impressed with first 3 points. Then the skill of good advocacy is that then immediately go to the other point. I'll give you an example. In beginning of my career, I could get few trials on the civil side. So it was a hopeless case. I was given a brief of defendant. The suit was based on negotiable instruments, money recovery suit. So I started cross-examining the witness. I was only 1-year-old lawyer. So I asked some question, judge disallowed it. Second, third, fourth, fifth, 7 questions were disallowed. And practice in Maharashtra was that one question is disallowed, you have to make application in writing and seek ruling of the court. So this went on for 1 hour. Fortunately, recess intervened. A very senior lawyer sitting there. He said, "Young man, come with me. I'll entertain you with a cup of coffee and batate vadas." This very famous thing for lawyers in Bombay. Then he said, "Arey, young man, you are committing blunder. Don't fight with the judge. If first question is disallowed, you could have said, 'Yes, sir, I agree that this question should not be allowed.' Then ask few questions. Then ask the first question by using different words. The judge would surely allow it. So this is advocacy. If you start arguing, say, I'll give you an example. You are making final argument in a civil suit where you feel that suit is barred by limitation. It all depends on upbringing of the judge. Some judges hate defense of limitation. And therefore, if you start arguing the first point that suit is barred by limitation, then you are committing a blunder. And how do you develop art of advocacy? The basic principle is, as you have to study your brief, you have to study the judge. It's very important to study the judge. I remember my seniors in High Court used to tell me, I had 2 seniors, they used to tell me, whenever a new judge is appointed, they used to tell us that, look, for first 8 to 10 days, I am going to observe that new judge. So till that time, don't venture to argue any matter before that judge. Because we must study the judge. This essential part of art of advocacy, that you must study the judge. You must understand what is the approach of the judge, what is the outlook of the judge. So that's very important. So therefore now, I'm sure that some of you are final year students. When you join profession of law, please remember that you have to learn lessons in art of advocacy, because without learning art of advocacy, you will never succeed. And you have to also remember one thing, that don't be under impression that every case has to be won. The reason is that you are first officer of the court and then mouthpiece of your client. As I said few minutes back, that ultimately your duty is to convince the judge that your client has a good case. But at the same time, there is another responsibility on you. That another responsibility is to assist the court and to ensure that justice is done correctly. And therefore, as officer of the court, you have to be fair. I'll give you a classic example of fairness of a lawyer. In Bombay High Court, we had a lawyer who was known for his fairness. And you know, some of you know, those who have studied CPC, that in second appeal, unless there is a substantial question of law, second appeal will not lie. So he was so fair that where he was not convinced that there is no substantial question of law, he would simply get up and tell the court, sir, I don't think there is any substantial question of law. But you know how human mind works. So I have seen, whenever he used to utter two sentences on merits, the judges used to frame substantial question of law straight away, because they knew that unless there is substantial question of law, this man is not going to argue. I was a new lawyer. My senior called me up. In those days, mobile phones were not there. He said that the file will be lying on my table. I am very unwell. I am suffering from fever. So there is a 1 second appeal. You have to appear for respondent, argue the matter. I had never argued second appeal by that time. So I hurriedly rushed. I picked up the file. I was glancing through the file. The judge was very tough. The person, the same lawyer whom I gave example, he was sitting next to me. So he saw me reading he said, I am appearing in this for appellant. You are going to appear? I said, of course I am going to appear. I was carrying, it was some point concerning Hindu law. There was a direct judgment of one British judge, which was reported in Bombay Law Reporter. So in great hurry, I could get hold of that judgment. I was carrying that book because in those days, photocopying was not easy. I'm talking about 1984-85. So the senior lawyer said, I want to see this book. I was taken aback. I said, this was my thumb card. I am going to succeed on the basis of this judgment, and why should I open my cards and show to my opponent? But of course, very senior man, I handed over the book to him. When matter was called out, he got up, he said, this young man is right. This is covered by one of the judgments against me. So I met that lawyer in the corridor. He told me, my worry was different. My worry was whether you are carrying the right judgment, and therefore I took that book from you. So these are the kind of members of the bar I have seen in Bombay High Court, because they were all sure about one thing, that their duty is to act as officers of the court. And one last secret which I want to share for the benefit of the young law students who are going to be tomorrow's lawyers. When we sit in the court as a single judge, I'm talking about sitting in trial court or in high court, it's a very lonely place to sit on the dais. Therefore, as judges, we like only those lawyers who are really fair, because then we don't have to exert more. I know that this lawyer is going to be very fair with me. He will show judgments against him. So this is a great advantage of carrying reputation that you are a fair lawyer. That's one of the keys to the success in legal profession. That's a secret which I am divulging. So I don't want to take much time, because now most important part of the function is prize distribution. Last thing, there can be very few winners, I think 2 or 3. There will be many losers. But don't take your so-called defeat in the moot court competition very seriously, because it's just like a game. Today somebody is winner, tomorrow you will be the winner. And what is important for you is the experience you got of participating in the moot court, addressing the judges who are judges for this moot court. That's the most important. Getting that experience is most important. And even if you today, you may have lost in the moot court competition, most of you will be winners in the bar. Most of you will be successful lawyers of tomorrow. So don't get disheartened because you don't get prize, because prizes can be given only to selected few. I wish great success to all the students from India, those who have come from abroad. If there are students from abroad, I'll request them to come to our course, see how Indian legal system functions and how difficult is the functioning of the court considering the number of cases which we get. So you'll be also enriched with experience of Indian courts. So if you have time before going back to your own country, please visit some of the courts in Delhi. I wish all of you a great success, and I thank the organizers and members of Luthra family for giving me this great opportunity to interact with the young lawyers. Thank you.
Thank you very much, sir. The views you expressed and experiences you shared will surely prove beneficial and will encourage us to seek excellence in our future endeavors. And it also compels me to share with you all on women shining in the legal field that all the 4 semi-finalist teams in this competition were all girls teams. A huge round of applause for that achievement, ladies and gentlemen.
Now, the most awaited moment of this ceremony has arrived, when we are acquainted with the winners of this prestigious Moot. I request the Professor in charge, Campus Law Center, Professor Dr. Gunjan Gupta, to come to the podium and kindly announce the various prize winners.
First is the category of the best speaker and the second best speaker. The prizes in this category are decided on the basis of the total scores scored by the speakers in the preliminary rounds of this moot court. The prizes being awarded in this category are 25,000 rupees cash prize for the best speaker and 20,000 rupees cash prize for the second best speaker. Books would also be given by Mr. Dinesh Dudeja of Ekta Publications, which are awarded every year traditionally, and this year by Subhash Sharma, a friend of Luthra family. I request Honorable Mr. Justice Harish Vaidyanathan Shankar to give away the prizes to both the speakers and request ma'am to announce the names.
I'm sure you all must be very anxious to know. To start with the first prize in the category Best Memorial. I'm sorry. In the category Best Speaker, the prize goes to Miss Dakshani from Himachal Pradesh National Law University, Team 2527. Dakshani. A huge round of applause for Pratishtha. You're waited here. Yeah, she's from Galgotias University, Greater Noida, Team 2534. Congratulations, Pratishtha. So the next prize in line is with regard to the best memorial. The best memorial goes to the team 2510. कर रही हूँ ना मैं This team is Lloyd Law School, Greater Noida, UP, and the team members are Ayush Sharma, Priyanshu Ranjan, and Ashutosh Mishra. Congratulations to you.
The winners would be receiving rupees 25,000 cash prize along with books from Mr. Dinesh Dudeja. I kindly request Honorable Mrs. Justice Mini Pushkarna to give away the award along with sir. I request Honorable Justice Mini Pushkarna to kindly come and give away the prize to the second best memorial.
The second best memorial prize goes to the team 2543 from Maharaja Agrasen Institute of Management Studies, Rohini. The team members are Monica Roy, Madhav Jewal, Abhinav Pratap Singh. Many, many congratulations. Where's your team member? A huge round of applause for them.
The team has won the second best memorial prize. Ladies and gentlemen, a huge round of applause for them. Now, I would just like to highlight that the Best Memorial awardees got 25,000 cash prize along with books from Ekta publication, and the second Best Memorial awardees got rupees 20,000 cash prize along with books from Ekta publication by Mr. Dinesh Dudeja. Now, the biggest awards of the day are due to be announced. The winners and runners-up. The winners would be awarded rupees 30,000 prize money and books from Mr. Dinesh Dudeja, and the runners-up are going to receive rupees 21,000 cash prize along with books from Ekta publication. For the winners, I request Honorable Mr. Justice Abhay Srinivas Oak to kindly do the honors. Ma'am.
Okay, the most awaited prize. The winners for this competition are the team. Any guesses, please? They are, of course, girls. Okay, the winners of this competition, they are team 2541. And they are from School of Law, Sastra, Deemed University, Thanjavur. Many, many congratulations. A huge round of applause. These girls, they've done a great, great job. Prize, bata do, prize and the prize what they have won, I think so you need to know that also. Please, Sunny.
25,000 rupees cash prize from the Nirmal Luthra Foundation along with books from the Ekta publication by Mr. Dinesh Dudeja. Now, thank you, sir. Now, for the runners-up, I request Honorable Mr. Justice Amit Bansal to kindly hand over the prizes.
I think so you know now who the runners-up, but let me announce you. The runners-up for today's competition, they are the team 2511, that is Guru Gobind Singh, Indraprastha University. They did a fabulous job. Many, many congratulations to you. Team members nahi batana.
The prize winners are getting rupees 20,000 cash prize from the Nirmal Luthra Foundation, along with law books from Ekta publication by Mr. Dinesh Dudeja. A thunderous round of applause for the winners, guys. Don't let it fade.
Thank you so very much, sir, for doing the honors. Thank you so very much, sir, for doing the honors. Thank you so very much, Gunjan ma'am, for announcing the winners. Now, I would like to invite Mr. Gautam Khazanchi to ascend the podium and deliver the vote of thanks.
A very good afternoon to all of you. I won't take much time. I think there's a small matter of an India and Pakistan cricket match, so I'll make this quick. Justice Oak, Justice Bansal, Justice Muskarna, Justice Vaidyanathan Shankar, on behalf of the foundation, I welcome you all and I thank you all for your presence here today. It is indeed a privilege and an honor for us that you have taken out this time on a weekend which we know is so valuable to you. I would also be remiss in my duty if I fail to thank the two most important people here. Ma'am, Professor Dr. Gupta, who's the acting CIC, we have to please, can I have a big round of applause for her? Similarly for Professor Suman Yadav, is she here? Yes, Professor Suman Yadav, please, the convener. And obviously all the student volunteers and the conveners, this would not have been possible without you. So thank you so much on behalf of the foundation. This year is a bit extra special for us because it is also the centenary year and the 100th year of the birth of my grandparents. And we are very happy that all of you, friends and family, there are so many people I see here who have supported us throughout this journey, making this 21st year one of the best years that this competition has seen. I must point out, before I thank anyone else, some friends who are here. Justice Amitava Roy, I can see him there. Professor Khanna, who comes every year. A big round of applause for Professor Khanna, please. Thank you, sir. The various friends of the family who I can name, but I will obviously not be able to name all of them, but I will name some. Deepak Luthra, Rajan Dahiya, Gopal Dikshit, Swamiji, Subhash Sharma, thank you all. I would also like to just inform you all that there are some unique contributions to this year's prizes as well. And we must thank those people. Justice Deepak Verma has graciously contributed to the Nirmal Luthra Foundation for the purpose that some lesser privileged indigent students can be helped of CLC. A big round of applause for him, please. I also have now a surprise gift for the winners, and I hope you are not going to get more excited than you have already gotten excited, but it's a surprise gift. From the Parekh family, the winners have got a 2 nights, 3 day stay, complimentary stay at the Leela Diva Hotel in Goa. I also see Sri Avtar Singh Sethi, a cousin of my late grandfather, who has also contributed to the prizes today. A big round of applause for him, please. And as you all know, Mr. Dodeja, like every year, has contributed to the books which every participant receives. Please, can I have an individual round of applause for him as well? This annual event has actually become a gathering spot for not just lawyers, but also family members and colleagues at the bar. Today morning, I had a very interesting conversation with one of the senior advocates who came to judge the semi-final round. A senior advocate, Mr. Ragen Basant from the Supreme Court. He told me that he was here in 2005 to judge as a preliminary round judge. And over the course of the last 21 years, he has now made it to the semi-final. I told him there's only one level left now. Lastly, I thank all of the participants. Without you, this would not have been possible. So thank you all for coming here and gracing this occasion. A big thank you from our family and the foundation. Thank you.
Thank you so much, sir.
When Sir shared that it's the 100th birth anniversary of Shri K.K. Luthra ji, I saw Sir getting emotional here. And it also makes me emotional that it is my last KKL along with all my third year CLC Moot Court members. With this, we come to an end of the prize distribution ceremony and also the end of the magnificent 3-day extravaganza. That is the 21st KK Luthra Memorial Moot Court 2025. See you next year, same time, same place, with renewed vigor and unmatched enthusiasm for another round of competitive mooting. Until then, this is Sunny Singh.
And this is Chaitanya Kapoor.
Signing off from this August ceremony. Thank you so much, take care and happy mooting. Now, I request the organizing committee members to escort the guests along with the dignitaries to the dining area for high tea, and I request the participants to stay here for the prize distribution of the certificates and the books. Please. Yeah. Request all the participants to stay back to collect their participation certificates and the books from near the stage. Call them one by one. Call them one by one.
Yes, you please just stay. यहाँ से